presentations. I'll just bring up the. That's mine. So we don't have a presentation. We have comments. We have comments at this point from. We have comments at this point from Fernando, who is previously the Chief Executive of the Brazilian Competition Commission and has been instrumental in developing the COMPAL program, of which has been conducted by UNCTAD. So without further ado, I'll just call him up.
Well, good morning. I don't have any presentation. I just wanted to share with you our experience under the advisory group of experts of COMPAL programs. I was invited to become member of the advisory group of experts of COMPAL. At that time, I think it was COMPAL 2 in 2009. And I've been there since then. It's a very, very good experience. I was chatting with somebody during the coffee break, and I have had some of the most rewarding experiences while I have been working with the advisory group of experts of COMPAL programs at UNCTAD. We basically the advisory group of experts is composed by former competition officials all over. It started in Latin America, so all over the countries of Latin America. We have bi-monthly conference calls where we discuss the ongoing projects, the problems faced, what is the agenda for the coming weeks and months. So there's always something to discuss during the conference calls. An update of the agenda of the project. And, well, I can mention to you some projects that I was involved in. As I mentioned, they were very rewarding, especially for me. For example, I remember I was still at CADE when I was asked by UNCTAD to help them in Paraguay project. Paraguay at that time had no competition law, no authority, and we started to work towards Paraguay, I think in 2010. Probably you had done something before that, but I started with the project, I entered the project in 2010. And it was very tough. We had many trips to Paraguay, and fortunately Paraguay ended up with a competition law, but with a modern competition law, which was approved. And now they are structuring the competition authority. So Paraguay was a difficult project, but fortunately it was a successful one. Bolivia also, they don't have a law, but they have a presidential decree, and we help them also structuring the authority. We have done some capacity building projects over there, as well as in Ecuador. They have now a powerful competition and regulation authority in Ecuador. We have done some capacity building projects over there. And most recently, last month, I was invited by UNCTAD to,
sorry, because they are live streaming.
To come with them with 3 MENA region countries. those were Jordan, Egypt, and Lebanon. So we spent about 15 days, 2 weeks in those 3 countries with a full agenda, everyday interviews and meetings with stakeholders from government, from private sector, private associations, consumer protection. It was a really full agenda, but it was really rewarding to, it was a kind of a diagnosis. We went there for a fact-finding mission and trying to understand what is the status of the competition and consumer protection projects in those countries. We discovered a lot of things. I think there's a lot of things to do, and more in some countries than others. But what is important to understand is that I once had a boss who told me that it's wiser to learn from our own mistakes, but it isn't even wiser to learn from others' mistakes. So a lot of things that we have witnessed in those countries we have visited and helped is that many of their problems we have been there before. So we have had those problems, the same problems in our own jurisdiction. So from what we learn from those experiences, we can pass on to those countries to help them and in solving their own problems. So it's really what I think really works with UNCTAD COMPAL programs is the sharing of experiences and how to build projects and build diagnoses and build strategic plans for the future based on each other's experiences.
Does anyone have any questions for Fernando before we move on to Carl? Or perhaps you might think about them and we can ask them at the end.
Sure.
So our next speaker to make comments is Carl Buick, and Carl is an Australian who previously worked for a long period of time at the ACCC on both consumer protection and competition law matters, training, compliance, the whole gamut of things that a competition agency might do. He subsequently worked for a company in Egypt, but he has done consulting work for UNCTAD and for other competition authorities. So I give you Carl.
Thank you, Deborah. Good morning. I was first introduced to COMPAL back in 2010. And at that time, I was very impressed by what I saw, because what I saw was a development program that had some really key elements that made it work. First of all, there was the emphasis on peer-to-peer learning, peer-to-peer support. What that did was it created a sustainable program. It meant that there was a life in the program away from, or not always driven by UNCTAD, or indeed the donor. It also mitigated against the problems of the inevitable lags when one country's legislation is slow in coming, or amendments take even longer, when the policy is demoted to a lower priority for a few years. Because there was a sizable group of countries, it meant as a whole the development of competition law continued. Another aspect I thought was particularly important was the relevance of what was being done. Because the countries had a similar historical legacy, because they were sharing their experience, it meant it was easier for the institutions to take on board what they were seeing. They had a sounding board in the other institutions. But I also was impressed by the linkage between consumer protection and competition. It had a number of benefits, including, very importantly, creating a champion for competition policy. Consumers who are engaged in the development of consumer protection were able to see that the best competition law of all was going to be a well-implemented competition law. And I think that was particularly important in adding impetus to the spread, the development and the implementation of competition laws around that region. Now, I've spoken to Pierre since about how COMPAL has developed, and it seems to me that it could be best described as a conscious evolution. It's an evolution based on critical review of the experiences. It's also an evolution based on adaptation to a changing environment. Within COMPAL, of course, there's been the COMPAL region initially in South America, there's been huge changes, and COMPAL has changed with it. Now we are seeing a further evolution, a conscious evolution to COMPAL Global. There's two particular elements of that evolution that I would like to note, and I'd like to talk in just a little bit of detail about one of those. But the two areas that I am particularly interested in is the increased emphasis on public sector involvement and private sector involvement. Now, I think with public sector involvement, one of the key things that I see from COMPAL is emphasising that competition law is one element of competition policy. I think too often around the world we see competition law being oversold to the extent that sometimes the tendency to say, okay, well, we've got a competition law, that's it. Inevitably, of course, it's not going to deliver the goods. I also think that the emphasis on direct engagement with policy departments and regulators is a great part of the evolution. I've been working with Pierre just recently in ASEAN, and to take up Bruce's comments, and I think Bruce is not here now, of course, when it comes to consumer protection, there is fragmentation. That's inevitable from the point of view of the legacy that most countries have, the historical development of particular services or technical areas serving the public. So I think when we look at consumer protection as a whole, it's hardly surprising that we have responsibility spread out through agencies. That's part of the environment in which we operate. But I think COMPAL Global has recognised that and is directing more effort to talking to policy departments and to regulators. Now, the area that I want to concentrate on for the next 2 minutes is the increased emphasis on engagement with the private sector. Now, years ago, there was a fairly fruitless debate about regulation, public regulation versus self-regulation. And I say fruitless because invariably self-regulation was seen as an alternative to public regulation. Not surprisingly, often the conditions weren't right for self-regulation to work. There was some very precise conditions that needed to apply for it to be in any way an effective substitute for public regulation. But COMPAL Global is not looking at self-regulation in that sense. It's looking at empowering businesses to voluntarily comply with competition law, consumer protection law. Now, I think that's a big shift. And I say empowering businesses quite deliberately. We usually talk about empowering consumers. What do I mean by empowering business? Surely business is powerful already. It's really about giving business the tools to comply. Now, in the past, COMPAL, as lots of other development projects, have emphasised advocacy and education. Now, if business know what the law is, then they'll comply. The emphasis now, I think, is shifting to realise that if we engage with the private sector, we need to help them. We need to give them the tools to be able to comply. And by comply, I simply mean to manage their compliance risks. Everyone around this room understands that corporations manage lots of legal risks, and the competition law, consumer protection law is just another one on the list. But we can give businesses a head start. And indeed, if we look at ISO 19600, which came out, I think, in December last year, it provides a systematic regime for corporations to comply with the law. And I think that the main elements of that will come through in the dialogue that COMPAL will be having with the private sector as COMPAL expands. It's always, I think, a reasonable question to say, that sounds good, but will it work? And I can speak from experience. Deborah mentioned I'd worked in Egypt. I was asked to design and implement and then manage what was probably the first, if you like, Egyptian homegrown competition law compliance program. A very large manufacturer engaged me to do that before the competition law came in. At the time, there was cynicism. People said, well, why do we need this? One, there'll never be a competition law in Egypt. Two, if there is, it won't be implemented. Wrong and wrong. The competition was implemented, competition law was implemented. The company I worked for had between 60 and 70% of the domestic production of the products it was producing. It was obvious it would be a target for investigation. Invariably, it was investigated. And the finding was that there was no contravention of the law. Now, I had emails from all over the place congratulating me for getting the company off, which really incensed me because the company had shown leadership at the top level. This company is going to comply with the law. It provided the resources, it provided the support, and it gave me the tools to look at the risks for the company, to make changes, to self-monitor, to report. What that meant was the company was on the front foot when it came to investigation. But I guess I'll finish up now by saying I think the way COMPAL has evolved means that it's going to be it's already an effective program, it's going to be even more effective because it's going to be more comprehensive, it's going to be even more rigorous, and I think that it will deliver very significant results in the longer term because it's sustainable, it relies on peer knowledge and peer review, but it has the ability to get relevant experts and to put them in at the right time, at the right place. So I'd certainly recommend COMPAL Global as a very worthy successor to the original COMPAL.
Thank you very much, Carl, and also Fernando, for those interesting insights into COMPAL. Does anyone have any specific questions for either of them about the COMPAL program and its extension? Yes.
Yes, hello. My name is Rainer Lindberg. I'm from Finland. I would like to ask from Mr. Puig, for instance, about what role does competition policy play, if it plays any role, when a foreign company is wondering whether to invest in a country. For instance, a foreign company is coming to a country to invest directly, setting up a factory and so on. And in that case, I guess they will take into account what's the labor cost and what's taxation, etc. These things sound actually very important. But what is your experience?
Yes, I think your question would be probably best answered by the major corporations, but from my observations, any company is making a series of judgments about risk. Are we going to be able to source our products at the right prices? Are we going to get the labour force on and on? One of those is rule of law and the nature of those laws. Now, any international corporation will be very familiar with competition law. That won't surprise them. They understand the rules. I think that, of course, in the immediate short run, there might be some companies that say, well, if you don't have a competition law, this is great because we can get in and do what we like. Clearly enough, in the long run, and for most companies who aren't in a position to benefit from any competitive conduct, I think that most companies are going to say, we understand that it's properly enforced with public decisions, a proper process, with a competent, approachable agency. This is a plus. It gives the country a competitive advantage. It also gives the companies who grow up in that regime of proper enforcement a competitive advantage when they move. But I found it very interesting. I actually was approached by a large multinational when I was in Egypt to implement a compliance program for them. That company had a very well-written compliance program, best I've ever seen. That company also has an appalling track record around the world. So it didn't take much to work out that where there was no competition law, things would happen, but it was quite capable of adjusting and it was intending to adjust.
Yes, one more question.
My name is Mia Kong, and I'm from the Competition Commission of Africa. I just want to get a sense of what the ultimate aim of the government is. The reason why I'm asking that is we understand there is money and there is combat with now we continue production. Is it to ensure some level of foundation on competition policies, or is it to perhaps bring about the enforceability for a free future? And is there some level of institutional foundation with all these global institutions, ICN, so sometimes get a sense of, so that one gets a sense of where we are going, or is it just to iron out national issues towards the region and take some common set of complementarity?
Pierre might be the best person to answer that one.
Well, I would like also compliment. We certainly have as an ultimate goal to promote competition and enable competition environment and consumer protection environment all the countries that are members of this program. But this is a long-term intervention. So what we have done in COMPAL that started in the Americas, we actually included a number of objectives that were intermediate objectives, like, for example, strengthening the capacities of the forces of the competition authorities and consumer protection authorities to create an enabling environment in this particular country. But before that, you will have to create also specific type of policies that will help these authorities. Now, the evolution, as are made very clear, and I think this is the best description, is that we believe that there is more and more commonalities of the countries. We could have not done this global strategy back in 2003, for example. It will be very difficult because the level of development of different authorities varies too much during that period. Nowadays, there are more younger competition authorities that they can actually share between each other the similar problems within different regions and across regions. Now, that's why our colleague from Mexico was saying UNCTAD is going to stop doing what he was doing before, like, for example, training medium and low officers on competition enforcement issues. Are they going to stop? I said, no, I'm not going to stop, but I'm going to reinforce by providing additional experiences from other countries that are at similar level of development. So if you want, there is going to be a great sense of convergence in terms of the practices, the good practices that can be shared between the member countries of global COMPAL. Yes, there is a good sense of convergence in terms of not only enforcing their rules, but also how to approach specific sectors. We know that this strategy is not only working with agencies, it's also working with private sector, and it's also working with public sector. So there are three, if you want, pillars of the new strategy that was not so straightforward, if you wish, back in the years 12 years ago, for example, this regional program. So there is a certain level of institutional, if you wish, vision of what we are aiming at the domestic level. So that's what there is a national component of the program. So we're talking about what the businesses would like to see in terms of their own institutional workers, in terms of their own business doing, what the public sector will see the competition authority and competition agency, not so much isolated to the mainstreaming of work that they want to pursue as developmental objectives, and also what the consumer associations and the consumers at large will also see their institutions gaining legitimacy of their work. So if you wish, at the national component, we will pursue this type of objectives. Now, the national component, at the beginning of COMPAL in 2003, we only having one of the three pillars only. Now we're extending these pillars into the private sector work and public sector work. Now, the regional component is a different level, because there we're actually putting the country as a whole. There is an instrument that works pretty well that already have described by Fernando, which is ex-heads of competition agencies and consumer protection agencies work together when they are outside the government to provide the opinions to the activities that are happening in their own country and all the other countries. So there is the regional advisory group of experts that will help to have the objectives at the regional component. And what is the objective of the regional component? And that is, first, more regional cooperation in order to fight against cross-border practices. That could be anti-competitive, or that could be restraining consumer rights directly in terms of specific sectors that we are working also with the ASEAN region, because there's a sectoral consumer protection enforcement. So the regional component is quite defined as well in this second level of analysis. Now, the last level is the evolution that was referring Karen. I think it's his word that it will be more effective and rigorous, because having a global component, it's a challenge in itself. Because we're talking about regions that have different type of dynamics, if you wish. Of course, there are certain levels of comparison if we actually disaggregate these regions, for example, by sectors. So that could be one of the approaches that we could take. For example, if we take one specific sector that could go across regions, we can actually certainly have some levels of benchmarks between sectors. So the global component will have to raise issues that are of similar concerns by the regional groupings that are part of COMPAL. So if you wish, this is a systematic view of the approach, divided in 3 levels, and each level has its own objectives. And of course, expanding the objectives to different actors that were not part of the global compact is a main challenge that we're having in this new approach. And we hope that we will have the support of the member states of the UN. I don't know if Fernando wants to add something else.
Well, I can't speak for UNCTAD, of course. It seems to me that substantial convergence of competition law is really driven by the fact that economics is universal, so the theory of economics applies universally. So it's not surprising that with trial and error, what seems to work, what doesn't, the core of competition law will converge. I don't think that's a surprise at all. I think that there'll always be differences when it comes to triggers, thresholds, whether things are notifiable or not notifiable, because a lot of that will depend on the stage the economy's at and the size of the economy, plus other policy objectives. That seems to me, when it comes to some of the little detail, there'll always be differences. And at the policy level, that's where there'll be always much bigger differences. But I guess each country is driven by its own desire to maximise welfare, and that's the common driver. But also, of course, international trade is increasingly a driver because countries like to feel that they have less impediments to getting involved in foreign countries. So, of course, that's a big driver. But I think at the end of the day, it's self-interest will drive a lot of convergence.
Even though UNCTAD worked with a model law, for example, that's just a reference. But I think it's very important to understand it that the COMPAL programs and UNCTAD itself works toward helping countries in how to build their own systems, their own law, their own legislation, their own competition institutions, but respecting each one's choices. There's no one size fits all. And the important thing is to evolve at the stage where the country is concerning competition and consumer protection. Sometimes it's important to take one small step, but it's one step forward. So this is something that we have been trying to do.
There's one more question here.
Mine is just a comment, madam. Listening to this whole thing is really interesting. But what worries me a little bit is that there doesn't seem to be enough emphasis or efforts to bring out the role of consumerism in driving economic growth and in making the enforcement and regulatory aspects of restricted business practices much more easier to deal with and less costly to the economy by roping in consumers, because whether it's household consumers, institutional consumers, at the end of the day is when consumers are aware of their rights and can bring them out very forcefully, will any business pay attention to doing business fairly and making sure that they comply with the laws that promote fair competition. I think we seem to downplay the role of the consumer in any economy. Even generally, when people talk about economics, there's less discussion about the consumer. Yet without the consumer, there's no economic growth, or there's no economy at all. Because at the end of the day, it's the consumer who has to put money in their pocket, buy goods or services, so that any business can remain viable. I think this whole thing needs to also focus from that angle and say, what impact will consumers, by becoming more and more aware of their rights and seeing their interests being upheld, play in making the enforceability of competition regulation more effective and perhaps more productive in terms of making compliance easy.
Who would like to respond to that one? To a very good point.
Yes, well, certainly the issue of consumerism is something that we started right at the beginning of the work of contracts in capacity building, because we have seen that there are two sides of the same coin. We already said earlier about how difficult perhaps is sometimes to work on a sort of coordinated basis with consumer agencies and competition agencies. It's really difficult to do it in different settings, domestic settings, and also about the fragmentation of consumer protection enforcement. It's so clear, and that's why part of the challenges that we are now addressing in this project that we have in the ASEAN region is how to come up with some holistic approach for the role of consumers in driving what you point saying, because it's really important that the only way is to have certain level of playing field. And this playing field we have tried in accordance to the economic integration of the ASEAN political agenda is to divide it into 6 areas. Because it doesn't mean that these are all the areas where consumers are. No, but at least this is a political agenda that has been driven by the member states of the ASEAN region. And they have instructed the Secretariat to look into these regions because they think that in these regions, in these sectors, there are more exposure where consumer rights are being violated on a constant basis. And the fragmentation of consumer protection enforcement at the domestic level proves to be inefficient. So what we're going to do here is to strengthen the capacities of the enforcers handling consumer complaints at the level of these 6 sectors. But in order to actually come up with a regional economic approach, we will have to do one report for the 10 countries. Now, how are you going to merge the experience of Singapore with Laos or with Myanmar? How you can develop training materials that could be adaptable between these countries that have very different levels of development and also setting, as we learned recently in Singapore. So this is a challenge in itself. So it will be, we are aware of these challenges, but that's what I'm saying. We are piloting this program in the ASEAN region for the sectoral consumer protection enforcement. But already we are setting up our long-term intervention with the competition authorities of these countries, because we cannot neglect the 2 areas that are part of the same coin. So CAR is, for example, responsible for the area of e-commerce in this part of things. To the experience that he has, he will contribute to develop specific training materials related to consumer protection and enforcement on e-commerce. But it's not sufficient. We have to work on product safety and labeling. We have to go to healthcare services, on professional services, and also environment. They have asked us to work on environment. So this is a very, very complicated area, complex. So so we are aware of this problem, but we have to start for something, and we have to start doing something that is meaningful. And in COMPAL, doing holistic approach was an approach. Yes, was tested. Now we are evolving, and this is the evolution that we're trying to come up. Perhaps if it works, we'll continue doing that in all regions. If it doesn't, then we'll go back to the holistic approach we're doing. But this is a matter of doing and testing what we have to do in these regions. I don't know, Kyle, if you want to add something else?
No, I think you summed it up. I mean, I made the point earlier. In my mind, it's very clear that a well-functioning competition law is the best consumer protection law you'll ever get. And clearly, it must be driven by the whole concept of consumer welfare and what is the point of all economic activity. But saying that, we must be careful that we are rigorous when it comes to deciding our policies or implementing the law, because sometimes there are adjustment costs. And so we just got to be a bit realistic about what those costs are and who bears them. We've got to analyse that. Because sometimes there are unacceptable harm done as the market works. Other times it's an acceptable level of discomfort as the market changes. I endorse everything.
So are there any other comments or questions for any of our panelists? Yes, one here.
Thank you. I just want to say that I totally agree with one very interesting and one very necessary point. When we talk about the consumer protection and antitrust regulation, we should understand that the competition is not only for competition, it's for market development, and finally, it's for consumer welfare. So if we investigate cases, especially of abuse of dominance, we make a market analysis, and there are questions about the consumer choice of different products, how we investigate and how we learn the market borders. Second thing, when we investigate such cases, when we find the effect on competition, negative effect on competition by the abuse of dominance, and especially in such sectors with peers that we talked about, and phone and international services and air transport and etc., the negative effect on competition should be mixed with the negative effect for consumers. And in this case, when we finish our investigation, when we make our final decision, we prove and we find an evidence that such behavior has less multi-negative effects. And if we make a decision, we show to consumer that we protect their rights, we protect competition, and we basically solve two problems together. So that's why we should not say that we only deal with competition cases and we don't think about how will be the effect on consumer welfare and how can we protect the consumer rights. It should be a mixed thing, and we every time should analyze this thing and solve two problems together. And in such way, we can show our government that our work is not only for good words as competition development, etc. We are talking about and we are thinking about the welfare of consumers of every state where we work and when we regulate competition. That's the thing that we understand it everywhere. Thanks.
Thank you. One more question.
I'd just like to contribute to this interesting discussion about consumer protection and competition. I just want to also maybe bring from the point of view of Malaysia, since Pierre has mentioned so much about the ASEAN framework, and having worked in Malaysia on these two areas formerly, and even now to see it from a slightly different perspective. Let's say in Malaysia, we had our Consumer Protection Act in 1989 after a long time of bargaining for it. Eventually, it was enacted as Act. We had our Competition Act in 2010, 10 years later and all. And I can see the disparate growth in that sense. Partly, I think because competition straight away attracts all the corporations. And it's really a hot topic there, I'm told. And of course, even from all the conferences that I see around. I think the difficulty sometimes are a lot of ingrained perceptions. Consumers have always received so little profiling, and consumer associations and all used to have to tussle with the government, tussle with the public on it. So I think this seemingly new emphasis or increasing emphasis of consumer by competition authorities is really welcome, because I think this will provide the inertia and the growth that is really much needed, which consumer bodies and that part of it comes in quite difficult. So let's say just in terms of ministries in Malaysia, the Consumer Protection Ministry and all have always been, I think, placed on probably the lower profile because it doesn't seem to be so important compared to the Finance Ministry, the securities industries and all. So I think this is one way that UNCTAD, through this kind of emphasis, can bring the role of increasing role of consumer protection, which is important because essentially competition is aimed to benefit consumers. So I hope to also see that happening in Malaysia as well.
If I can add something to that too. I mean, Australia has been slightly different because it's always had its Competition and Consumer Act as one act. So we have our consumer protection provisions and our competition provisions in one act, and it's all enforced by the one regulator. And that's always been justified on the basis that both sides of the legislation are about creating a level playing field for business so that they can benefit consumers. So if people aren't price fixing, then prices are lower for consumers. But if businesses are not misleading consumers, then efficient businesses are not disadvantaged. So we've always seen it as a bit of a loop, and that the two go hand in hand. But that's easier for us because we've always had it in together. And interestingly, we've just had a big review of our competition law, and some of the people wanted the two sections to be removed, into separate regulators. But the recommendation is not for that to happen, to my great relief, because I see a real synergy between the two being, I mean, Carl would probably agree with this all, but the separate offices, separate parts of the commission deal with the different issues. You've got your competition part, your mergers, you've got your consumer protection over here, but there is some interaction between them, and it makes it far easier when it's in the same legislation and it's in the same regulator. So other organisations and at state level, there is a tendency for our governments to place consumer protection at the lower levels of the ministry, but they can't really do that at our federal level because they're in the one entity. So people might be interested in that.
And what glues the two sides together is customer value.
Exactly.
Really
And that's the rationale. We're all there to benefit consumers. Another question, Pusha.
Well, I'll just comment. At the regional level in the Caribbean, we have one law too for competition and consumer. And it's really integrated in the sense that one of the defenses available to a firm that would otherwise be found to have abused its dominant position is if a fair share of the resultant profit goes to the consumer.
That's, I think, similar to the EU. Yes.
My name is Kram Qureshi. I'm a commissioner in the Competition Commission of Pakistan. Just a comment on this issue. We have in Pakistan consumer protection courts, but they are not working very well because of the lawyers and the judges and all that complex system. But we also have in the competition law, there is a section 10 which directly deals with the end consumers. I see competition law as everyone is saying, beneficial, or the actions in the competition laws are always, the trickle down effect is for the end consumers, for the consumer. But we also have, directly a section, a provision, which deals with the consumer and consumer. The point that I wanted to make is that the jurisdiction like us, we always learn, from the developed jurisdiction like America or all these, or EU and all these. When we learn from these jurisdictions, we also learn, somehow mistakenly sometimes how to penalize parties. It is our experience in dealing with the end consumer protection that when we ask them, to comply with the law, they are ready to do so. But when we are learning from the developed jurisdiction, and when we take actions, let's say against the cartels and abuse of dominance and all those, and we want to penalize them, and obviously when we are learning, the heavy penalties, and we also want to somehow, give them heavy penalties. That's the point. That is there where those bigger companies, then they go to the courts or they they challenge our laws or our action. And it takes lots of time that for the settlement of the cases, because it is reviewable, the orders of the commission are reviewable before the appellate tribunal and the Supreme Court and everyone. And then I see there is a delay, actually for the benefits of the consumer. So what the agencies, and especially the younger agencies, needs to understand is that learning is good, but we should learn in our own perspective, in our own laws, in our own jurisdictions. And we have to have a balance, the balance between the enforcement and the penalties and the consumer protection and the compliance. And for that purpose, we have prepared one volunteer competition compliance code, but somehow I think it is not working, as it should be, because maybe the companies are reluctant, Then we have required, there is a requirement, that they have to register with us. Maybe that is the thing, that they are afraid of. Registrations of the compliance code with the competition authority. And that's how probably they think, that their actions can be seen by the authority easily. Maybe this is one of the issues. But my understanding is that the younger agencies need to have some balance between the enforcement and the advocacy in the compliance, volunteer compliance.
I think there was another question. Are there any other questions or comments on that? I think that there have been very many well-made points, and I think that you will agree with me that the new global COMPAL looks as though it will be a very productive arrangement, and we have to commend UNCTAD for the development and wish them great success on the implementation of it. So, thank you. We might finish the session there. Now, there's the last session is one which I am due to present. If I can find my PowerPoints here. And really, the next session is really about one of the research projects which has been assisted by UNCTAD, and which I had the pleasure to lead. And at the outset, I'm Deborah Healy. I'm an associate professor at the University of New South Wales. This is part of our university campus, which we reserve for business and law to have links with the city. Our large campus is about 15 minutes from here. If anyone is interested in going out and taking a look at that, well, I'd be happy to help facilitate that for you. I'm delighted to be able to tell you about this project, which I led for UNCTAD at their instigation. I spoke about competitive neutrality at the IGE in Geneva, I think in about 2009. And following that, the UNCTAD Research Partnership Project was established, and this university was one of the initial members of that project, that platform, Research Partnership Platform, where people meet to exchange ideas, and UNCTAD is very good at facilitating research across a whole range of areas. And that is in effect what happened with this project. It was very ably supported by the UNCTAD staff, particularly Graham Mott. And I was invited to lead the project basically because I've been an Australian lawyer and now I'm an Australian academic, and it was based on my knowledge of the Australian position about competitive neutrality and my interest in the role of government in markets, because I see the role of government in markets as one of the really biggest factors impeding efficient market workings. So when you look at government in markets, government can impact on markets even if competition laws apply to government. Someone said before, that's just the starting point. People say to me, oh, in our jurisdiction, the competition law applies to government. And what I would say is, that's fine. Does it get enforced against government? or is it just a window dressing? And then what about the other activities of government, such as the way that government makes laws and regulations? You know, laws and regulations can be made in a whole variety of ways, some of which are very anti-competitive, and other ways could be selected which achieve the same ends but didn't have those anti-competitive repercussions. And we, as part of our competition policy reform in Australia, reviewed all of our laws, and we had some crazy laws on the books. You know, you had to have a license to be a chicken sexer, you know, to select, to decide whether a chicken was male or female in producing eggs. You had to have a license. There were a whole lot of restrictive laws like that. I could talk about them for ages because I was involved in that review. Also, government makes policy, legitimate policy decisions to achieve a really positive end and something which is great for the citizens, but they often don't consider the anti-competitive impact of those decisions. Then the major one, which is relevant to what I'm talking about, is the way that government competes in markets. And in many cases, government doesn't consider its impact on markets, and particularly in developing countries where government has traditionally played such a large role in markets, people just assume that it's going to be there and continue doing that sort of thing, and they focus their attentions on, you know, the anti-competitive activities of multinationals in the jurisdiction or powerful companies, powerful domestic companies. And that's all very well, but government can often be the entity which has the biggest impact on markets. And what happens? Well, where government gets an advantage in markets, it means pricing doesn't really reflect the true cost of the government doing business. And it also means there can be flawed decision making. Governments can be operating in businesses where it would be far more efficient for private enterprise to be running the business. So I'm not suggesting governments should completely get out of the market, but there should be a consideration as to whether what they're doing is appropriate. And that's what competitive neutrality policy is all about. So if you look at the purposes of competition law and policy, they're aimed at creating a level playing field for competition where the most efficient competitor will deliver goods and services at the lowest price. That is the bottom line on competition law. And significant businesses, in government businesses in competition with the private sector, shouldn't have a competitive advantage over the private sector just because it's owned and controlled by government. So competitive neutrality policy is the steps that you take within a jurisdiction or the mechanisms you put into place to ensure that the market is neutral. You ensure that just because a body is run by government, it doesn't mean they have an advantage over potential competitors or actual competitors. If government business has a real advantage, it may deter more efficient private competitors from coming into the market. And as I said, this is not an absolute rule, and I'm not suggesting government should not engage in any business. But what I'm saying is that there needs to be a lot of consideration about where government competes and how it competes. And this has both national and international implications. And of course, the views of various jurisdictions about issues like this have a distinct relationship with their own views on industrial policy and state capitalism. So what are the potential competitive advantages that government businesses can have? Well, I've listed a lot of them here. You know, government businesses may have immunity from taxes. They may have immunity from certain regulations. They may be, one of the big ones is an explicit or implicit government guarantee on its debts. People know that the government will not let this entity go broke, even if it competes inefficiently. And this is a particular issue in China, where the government continually props up state-owned enterprises and has, and everyone dealing with state-owned enterprises knows that this is the case. Now, there are changes going on in China, but this is still a big problem there in terms of market efficiency. effective immunity from bankruptcy, and pricing policies which don't take full account of production costs is really important. On the other hand, there are potential disadvantages for government in carrying on business. They may have greater accountability through things like freedom of information legislation. In Australia, they continually get dragged up before Senate inquiries or other committees to justify themselves. They have to put out very fulsome annual reports and justify their activities. They have community service obligations. So all of these things which I've listed here are disadvantages of government businesses. So Australia has been described as, by the OECD, as having the most developed competitive neutrality policy in the world. So that's probably why we are asked to contribute to these sorts of arguments. And you may well think, well, Australia is an industrialised country, it's small, but why would it have a problem with government in the market? Well, I can tell you that, 20, 25 years ago, government played a very big role in our markets and traditionally had, because we were a far-flung outpost of the British Empire. We found it very hard to get investment in infrastructure. We had a very small population spread across a very large amount of land, mostly congregated in pockets along the coast. Rail is much more expensive. As an Australian, I can't believe how quickly you can get from one country to another in Europe. As I say to people, it takes me 6 or 7 hours to get out of the country if I want to fly from Sydney. And infrastructure projects such as dams, all of those sorts of things, and very many banks, everything was owned by government here. And we have systematically pulled government business out of our markets in recognition of the fact that government competing in competitive markets or potentially competitive markets can seriously distort competition. So what our national competition policy in 1995 said was that government participates in competitive markets, it should be dealt with in a systematic way. We introduced competitive neutrality policy, which was a process of adjustment. We sold off businesses which could compete. We introduced all sorts of accounting. We corporatised bodies and made them more accountable and made them operate more like ordinary corporations. And we changed the way that we allowed them to account for the way that they did business. We made them notionally apply government charges that were not traditionally applied to them. We made them notionally account for rents at a commercial rate, which they had been getting more cheaply. So, and we brought in principles of full cost attribution for significant business activities. And we supported all of this, as I say, by corporatisation, pricing directions when government bodies supplied to another, and very strict rules about tendering to support all of this. We also introduced complaints processes for businesses who felt that they were disadvantaged because they were competing in a market with a government body. And that's been operating in Australia since the late 90s. So we took a comprehensive approach, which has been relatively successful. We built on earlier reforms. We also already had a well-established competition law at the time when we did this. And we had a very, very unusual situation where the governments of all of our states and territories and our national government took a very forward-thinking approach to all of this and were able to agree to implement it. I don't know that that would happen now. We'll have to wait and see because we have new changes proposed. So why I raised those last issues, and of course, the important thing, incentives were given to all of the jurisdictions to comply with all of these mechanisms. And what the Productivity Commission estimated the efficiency savings which would occur should all of these things be brought in. And as territorial and state and national governments completed various aspects of all of this program, people were paid money, and that was a great carrot. Now, when it was reviewed in 2006 by the Productivity Commission, the Productivity Commission, in very summary form, said further commitment to better governance of state-owned entities and government corporations was still required, that complaints handling in all jurisdictions needed to be improved and documented. And I rang up one of the complaints handling bodies 18 months ago to take a foreign visitor there and said, could I speak to the person who deals with competitive neutrality? And they said, we don't have anyone. And I said, well, why not? And they said, because we don't get any complaints. So clearly that jurisdiction is not publicising its commitment to all of this. Importantly, the 2006 review found that rates of return are still below commercial rates for most government businesses. So we're part of the way there, but we're not quite there yet. And we've just had more broad review in 2015. A report's come out only a month ago, which has re-emphasised the government's commitment to dealing with government in the marketplace and creating a level playing field. And I won't read all of those bullet points, you can read them yourself. But in terms of competitive neutrality, the report called for further transparency, more detailed reporting on how complaints processes are being handled. And one of the things I see as a problem with competitive neutrality is there are some cases in which we haven't really determined what is or is not a competitive neutrality issue. And I think we need to do further work on that. So that was my background coming into this. And this is an example of a comprehensive competitive neutrality policy that has been working for a while. The OECD in 2012 recommended 8 priority areas of reform to bring about competitive neutrality. And some of those I've already mentioned. I won't go through that again. What I want to do is talk to you about the project which UNCTAD facilitated. And that is set out on the next slide, and you will have copies of all of these slides. In 2011, it was proposed to me that I should lead a project on this, and we raised this as an issue at the Research Partnership Platform Conference, which is usually adjunct to the IGE in Geneva in July. And the people listed here from China, Malaysia, Pakistan, Russia and Switzerland agreed to participate in the first stage of the research. And at that point, one of whom was Mei Chong, and at that point we set out for them a list of questions. What are the nature of government bodies within the jurisdiction? We were trying to work out who a competitive neutrality policy might apply to. And I step back and say, competitive neutrality is not absolute. Sometimes public interest does outweigh competitive neutrality considerations. But the big issue, and particularly for developing countries, is that this needs to be considered. You need to think about what government is doing. Is this the way we want to run this business? Is there a benefit in government continuing to run this business? And what's the detriment in the loss of potential competition? And you weigh those up. And you see here, we asked all of these bodies what was the nature of government bodies within the jurisdiction. And I think some of the participants had actually never considered this as an issue, never considered getting a handle on what sort of bodies government was actually running and within its jurisdiction, and whether it was a good idea for government to continue to do so. So I'll leave you to have a look at these on the PowerPoints, because I don't want to take up too much time. I want to leave some time for discussion at the end of this. But each of the countries came back with some answers on that. Then we came back with the issue of, does competition law apply to state-owned entities? And in all of the countries, they said yes, although in China it was theoretically, but the issue is more complex in practice. And some of the advantages and disadvantages of government ownership were identified by the participants. You can see Pakistan was a contributor. Is competitive neutrality addressed at all? Has there been corporatisation? What's being done about governance? Have you thought about some type of framework? And really all of this was to prompt the participants to consider how competitive neutrality might be implemented in their jurisdiction. And the assumption was never that everyone would want to do what Australia's done, nor would it be appropriate. But it was just showing the participants a way that it might be done, a way it had been done relatively successfully. So all respondents were at some stage of major reform through corporatisation. The less developed countries were further back on that scale. The level of transparency in government between the various jurisdictions varied greatly. No one had a mandated framework like Australia, which is totally unsurprising. Some respondents assumed, and this was part of it all, part of getting this across, some respondents assumed that the application of competition law in itself would solve problems of competitive neutrality. Oh, competition law, yeah, we've done that. Well, no, you haven't. You need an attendant policy of some description to support your competition law as far as government goes and as far as the activities of government may impact competition. Pakistan and Russia had advocacy options, which was seen to be very positive. And they also had complaints mechanisms, which surprised me given that both of those laws were relatively young. So that was, I found that was a really, really good thing. And then I asked the participants to select a couple of bodies within their organisation and how you might, within their jurisdiction, and how you might make them competitively neutral, how you might put them on an even footing with private enterprise. And that was really interesting. And a lot of this is in the book, which there's one copy left here, but the competitive neutrality website, sorry, the competitive neutrality project, it can be downloaded on the Research Partnership Platform website. And there's also a presentation that was used at the Research Partnership Platform conference last year, which I gave, explaining some of these issues a bit more. So each of the countries looked at selected bodies and talked about whether they were competitively neutral and whether they might be made so. And that was very interesting too. So that was the first stage, and we had two presentations at the Research Partnership Platform conference talking through those issues. Other people said, gee, this is really interesting, we'd like to become involved. Ultimately, we further developed the approach and the project and put the detailed reports of various countries into a book. And basically that talks about the consideration of the advantages which might accrue to SOEs. And I think that's useful as a competition law and policy consideration in any jurisdiction, in any event, just to make people think about what government is doing, what its footprint on competition is within a particular jurisdiction. In most of the jurisdictions, corporatisation had reached an advanced stage, and we thought that a complaints-based process involving the competition regulator was likely to be the most effective tool in most jurisdictions. And that would have the advantage of allowing competitors to complain where they believe the playing field was not level for them and competition regulator could make the call. Also, Graham Mott of UNCTAD addressed issues of competitive neutrality in a global forum, and particularly developed countries have become concerned where there are far more state-owned enterprises going out into the global marketplace now, and their concerns are that heavily supported state-owned enterprises may well knock more efficient, unsupported competitors out of various marketplaces, and steps are being taken to look at that in a trade context, although it's a very sensitive topic in developing countries, because they feel that often creation of national champions, which are supported, is the only way that they can actually compete in a global marketplace. So there's two sides to those sorts of arguments, I think. So in developing the book, I've got a list of our contributors here. We had 2 chapters on China. We have two chapters on Malaysia, one of which was, as I say, contributed by Mei Chong, one on India, one on Vietnam, and one internationally, and one by myself on Australia as a sort of a framework for consideration of the others. And it was a very interesting process for me. UNCTAD was fantastic in facilitating the further collaboration. And we invited those countries to compete. They're all developing countries at different stages. They were all non-OECD members. They were all in Asia. And all of them recognised the impact of competition on market efficiency and had competition laws, and all had reformed their businesses to some extent. So I'll just sum up what the findings were. Really, and some of these you would have suspected. The differences in the stages of competition law development affected the approach of the participants, but all recognised the impact of competition on market efficiency. All had reformed government businesses. All had reformed government businesses to some extent by methods, as I say, such as corporatisation, governance, transparency and accountability. Application of the competition laws to SOEs was an important feature as a law on the books, but some of them were actually enforcing against SOEs as well, which is very encouraging. Those from jurisdictions with a powerful commitment to industrial policy were understandably a little perplexed about the importance of the concept and less concerned about a lack of competitive neutrality in the jurisdiction, even though they were committed to more efficient corporations, more efficient state-owned corporations. They would only go so far in their thinking about competitive neutrality. But I think that raising the awareness of governments about the issue of competitive neutrality and its impact on markets really is an end in itself, regardless of what they ultimately decide to do. I'll just give you a few more, before I finish, just a couple more points about the individual jurisdictions. China and Vietnam clearly saw a continuing significant role for government in the market there, and that was strongly influenced by the ideological perspectives they had, particularly for their strategic industries. China thus thought a comprehensive policy was inappropriate, although some aspect would substantially improve the competitiveness of various industries. Vietnam was really not enforcing the Vietnamese Competition Authority, not really enforcing the competition law against government bodies. And in fact, where there are competition problems, the government is actually trying to strengthen their SOEs to give them a better competitive foot up. So I think that they're probably the furthest back in terms of thinking on this as of any of the jurisdictions looked at. But part of that is an ideological choice, and it's also keyed to their stage of development. I think they see their development, economic development, being particularly important. Malaysia saw a continuing role for government in the market from a development perspective too, but there's a lot of SOE development and reform is ongoing. So I think that that will continue, and ultimately issues like competitive neutrality may be relevant to them. India had really gone furthest in progress and privatisation, And they, at the time, were looking at a policy similar to Australia's competitive neutrality policy. They reformed government bodies substantially by corporatisation and privatisation. Whether they're still thinking about that competitive neutrality policy following a change of government, I'm not sure. I haven't spoken to anyone since. Vietnam was still actually creating advantages for government business, and it was a little bit unclear, in the words of the author, whether competition law was going to be a sword or a shield for SOEs in Vietnam. And the question given on the global scale is, can it be resolved by agreement? So we are now continuing with that research. We've put the book out. We are going to be doing a symposium in Australia at the end of this year and bringing some people over from developing countries. China has agreed to come, just to expose them to people in Australia who have had experience in the area, and the people in Australia are going to workshop developments in Australia going forward following our Harper review. But what I'd like to say is to greatly thank UNCTAD and its development of the Research Partnership Platform for facilitating the interaction and publishing this book. And I've also been involved in another project with Professor Eleanor Fox on competition law in the state, which some of you may have participated in, the questionnaires, etc. And we wrote an article on that published in the Antitrust Law Journal, which has actually just won an award. And what I can say is we would never have published that article or had the opportunity to put that material together without the assistance of UNCTAD's Research Partnership Platform. So I, for one, am extremely grateful for my involvement in it. And it's another tier of work that UNCTAD is developing and which has really grown since its inception in, I think, 2011. And it's something I would like to congratulate UNCTAD on. And I don't know if there are any questions or comments for me on what I've said, or whether you all just want to go now. But I'd be happy to take any questions on the Research Partnership Platform process or on the ongoing competitive neutrality project.
I'm surprised there is nothing on Pakistan on your book that you're going to write. Because we have done so much that now all the big entities that we have worked against, that we have passed the orders against, so that these are all together with all the bigger lawyers, the huge lawyers, and they want to finish us all, the agency and everything.
Well, maybe I should talk to you after this and we should do some further collaboration. Because what happened was some of the countries came back with very large answers, and we decided to go, which were mainly Asian countries, and we decided to push on with those.
We would like to help you if you need.
Thank you. I'd be very interested because it's clearly a very important jurisdiction that would be very well featured in something in our further research.
Yes. I was glad to see that there are some things about Russia, but I'd like to say that from 2011, lots of things changed, and we are developing in this question. And we realized a couple of years ago that if we talk only about ex post control, antitrust control of SOE, it's not enough. The thing that should be done is the ex ante control. And we're waiting for the new chapter in our antitrust legislation, our federal law on protection and competition. We already wrote it. And probably this year, FAS will have the power to control of the establishment of SOE. And every time when some government authority would like to establish such entity, they should file. That's the same as a merger control. They should file to antitrust regulator, and they should bring the evidence that there is a strong necessity of the establishment of such SOE. And our new chapter in Federal Law on Protection and Competition will include the closed reasons of SOE establishment, and the first and the really necessary thing that SOE should be established only in such kind of markets where competition is not developed yet. So every time when a government agency will file to FAS, FAS will make a market analysis, and FAS realize that the competition in such a market is already developed by private sector, by private business. FAS will not allow such establishment, and if FAS rejects establishment, this government authority would not allow to register such legal entity. And that means that the antitrust regulation in Russia will make a necessary border of participating of the government in such markets where the private sector exists and where the competition is developed by private entities. So that's why we think that the ex-ante antitrust control of such questions is rather more effective than we solve the problems ex post.
Well,
That's why we would like to share our experience with all of you.
I think some of that was foreshadowed in the response that Vladimir Kushel and your colleague gave to us in the other project in the competition law in the state, because I have heard something of that before, but clearly I need to talk to you going forward about that for the project going forward. Are there any other questions or comments? Yes.
Perhaps you just take a cue from what the speaker has mentioned. I'm trying to understand the rationale of competition neutrality. Why I'm asking that is, normally market failure could be an enemy of competition neutrality. Now, market failure is more about private sector. And going forward for a rational thinking, bringing in the element of competition neutrality, you know, government control more to the competition. Market failure only part of private sector activity gives rise to more government. Give rise to an element of more government, state-owned enterprises, ownership, economic management, and that allows a parliamentary process to happen, whereby regulation by its own definition tends to, how can I say, regularize the competition space on the part of government. And that induces more political muscle within the country. Now, going forward, for us in a developing country context, government involvement is appreciated more, especially if there is market failure. Now, to bring about a balance in terms of competitive neutrality will be very difficult to just allocate it on governance, allocate it on transparency, in terms of competitive neutrality to be realized. And that's the restraining factor, the limiting factor. Whereas private sector in itself, from an inefficient point of view, induces market failure. But on the other hand, competitive neutrality, the success of it can be compromised by the virtue of private sector not doing what it ought to do, and government taking and assuming more government control, thereby negating the success of competitive neutrality. That's what I'm faced with, that contrasting, contradictory, how can I say, economic power balance.
Well, what I would say is, you know, even in Australia, we recognise that in areas where there's market failure, different considerations may apply. And for example, in Australia, we have, but then you have to consider, you know, the public benefit and those sorts of issues. And I've said competitive neutrality is not absolute. In Australia, we are currently building a national broadband network to go to every house in Australia to supply faster broadband. And that's being done by a company set up by government, which is called the National Broadband Network Company, NBN Co. And in fact, one of the most recent competitive neutrality complaints in Australia was about the NBN Co. They couldn't get anyone appropriate to do the work throughout the whole of the country, and I haven't read why. But when you look at the size of the country and the amount of infrastructure investment and the sorts of costs you can charge, they've set it up. And what the ultimate aim is for it to be a fully functioning, sold off, privatized company. But at the moment, it is fully owned by government, okay? And so it was supposed to supply fibre to the node, and then and please, I'm not a great technician on all of this, so please bear with me. But basically, there was a point to which the NBN Co would supply the link, and then after that, the private companies were to tender or whatever to supply it to the houses, but the NBN Co could also supply it to the houses. And 3 companies who want to supply to houses complained about a variety of the behaviours of the NBN Co, one of which was their costing. The time frame at which they were saying that they were expecting to make a profit by 2020. And basically, it was considered by our Productivity Commission, which considers complaints at that level, and they said no, the costing that they were applying would not deliver a profit by the projected date. So they should, and they were costing that part of the product too low, and they needed to raise their costs. They were costing it at a price that their private sector competitors could not match. So, I mean, that's the sort of thing that we're talking about in terms of competitive neutrality. We don't expect that every government will run nothing. There are certain areas where it may be appropriate for government to run it, or government's the only one who will run it. But in that case, you should not block out the, by charging too low prices, you should not lock out the capacity of private competitors to enter the markets. One of the issues is if you are having community services obligations, they should be separated and separately costed. They shouldn't be factored into the pricing. So it should be done on a truly commercial basis. And it's not something which should be applied to every government body. We apply it to substantial government bodies, and they are certain government bodies with certain characteristics or having a particular turnover. So it is more complicated than I've made out in my presentation, but those are the basic principles, and we still have cases against government, and government is found to be in breach of the policies, disturbingly. Yes.
Yes, thank you. My name is Jukka Lehtonen, and I come from Finland, from this business, and I have just one point to make. I think you are talking about state and government, so meaning central government. But if you think about situation in the European Union, and especially in Nordic countries and Finland, in my country, I think the problem is not so much the central government, but the local government. I mean, municipalities, they are being more and more active in going to the totally in the competitive markets. You might be interested to hear that our local governments are active in sectors like catering services, healthcare services, waste management, even wedding services, husky safaris. I mean, they are really in a market where they shouldn't be at all. And I really like to hear what our Russian colleagues said, that there should be some kind of market test. I mean, why should public money go to the market at all if there is a healthy competition and nothing wrong in private market? So that's the point I want to make.
Can I just say something before we hear from our Russian friends? That in Australia it does apply. In Australia we have a federal government, which is a government made up of the states, which is our overall government. Then we have our state government. So we are the University of New South Wales. New South Wales is this state, and the university was originally owned by the state government. And then we have our local government. Now, competitive neutrality applies at all those levels. I just haven't mentioned that. And interestingly, when we had our recent review, our Harper review of competition policy, the review committee commented that most of the complaints that they had about competitive neutrality were at local government level. And they were things like waste services. I know we've had problems in the past with things like swimming pools and government's local government childcare centres competing against private operators. Gyms, the university had to, when all of this came in, my university had a free gym for all its students and free swimming. And we had to price it because otherwise we would be in breach of competitive neutrality policy and we would have had an advantage over our local competitors. So it does go through. Did you have any comments on that to make about the Russian situation?
We practically have the same situation because we are federation. So that's why the rules are similar as for federal level, as for state level, as for municipal level. So all these three levels of regulation in our country, the topics about competition neutrality and our idea of ex-ante control spreads through all these levels. And at the same time, I think that it's only this is the only right decision, because we cannot separate. In federal level we have one rules, in state level other, etc. Our antitrust rules are federal one. In a state level, no authority would bring their own regulation. The regulation is the same, and that's why no changes. I think that's only one way.
Just a comment. I think the governments, they are not in the businesses because to get gains, or the benefits, but they are in the business because of the political reasons, that they have to get. This is where the power lies, with the bigger corporations and with all the money and everything. The competition agencies, in my understanding, when we make some certain requirements for the government, when I talk about the government, it's the federal government or the ministries, not the state-owned agencies, because they are being run by the ministries or the federal government, all those people. When we make them requirements for them, they don't like it. I think the emphasis should be on informal kind of interaction between the competition agencies and those ministries or those governmental agencies. This is how we need to make them understand the benefits of the competition law. This can be done, through advocacy that we do in Section 29 of the Competition Act of Pakistan. We are required to do the advocacy. This is number one, and for number two is to issue the policy notes for the government or governmental based agencies, where we do the analysis and we try to make them understand, and then we can recommend, various recommendations, how you can conduct the business, and still you can be beneficial for your jurisdictions within the Pakistan, but at the same time you can give them more benefits by avoiding the anti-competitive actions.
Look, I think advocacy is very important, but can I say, when we started to implement this policy in Australia 20 years ago, the governments didn't like it. I can remember going home to my husband saying, this will never work until all these people are dead. I did, because they were so entrenched in their behaviour. But what happened was that they were given the incentive payments at the head of government level, in the states, and they began to see that there was something in it for them. And after their initial massive reluctance, they actually caved in fairly quickly. And we had a wonderful chair of our ACCC at the time, Alan Fells, who I know is known to a lot of people at UNCTAD, and he engaged in very, very, very successful competition law advocacy. And if I could suggest that one of the most important things in all of this is to have a very strong competition law and policy advocate within your agency and also within your government. And that I thought it would never happen. I really did. And it rolled over in 4 or 5 years. The organisations that I thought would never change and had been training, being brought in to train them about what competition law and policy was, they had no idea. They had never been subjected to competition law, our government agencies. They had no idea what it was about and didn't see why it had any relevance to them. And, 5 to 10 years later, they were all pretty much towing the line. Well, are there any other questions, or we might I'd call on Pierre. Would you like to wrap up, Pierre, or?
Well, just very, very much thank you, Deborah, for everything you have done. Graham told me that you are the heart of the RPP, and I think that I can see it, that you have put a lot of effort in this project, and I really thank you for that, and your university as well behind that. I think it's been a very important aspect of the work, and as you can see, it's being picked up as a major component of the new global COMPAL strategy, which is this issue of competition neutrality. So there is already the planning part to undertake a different formulation of competition neutrality strategies at the national level of the 53 countries that are part of this global COMPAL strategy. So we're going to need you more.
Well, that would be great, because it's actually dealing with all of the jurisdictions on these issues really opens your eyes. Coming from a small country where we think we have a very strong and effective competition policy, which we do, but going to other jurisdictions certainly opens your eyes on a whole range of issues. I don't know if May has any comment to make, because she was part of the process.
I can see from today's discussion that it has really tied all the various links. We started with competition, and then we went to consumer protection. And I think this is probably the new perspective as well, of competitive neutrality. Just seeing how it goes, I think the loop will continue. So it's really great.
Thank you for your contribution to the project, and I'm hoping you will continue in the next leg. Right, well, look, I don't know if you want to say anything about wrapping up today's proceedings.
I think I've said a
been
lot already. So.
Well, we'd just like to thank you all for coming, and it's a delight to have you all here at our university, and I hope that your discussions at the ICN itself are very fruitful. So thank you all.